Item 26 and 27 for judgment.
Pronounce on. Writ appeals are allowed, however, considering the fact that the impugn orders of promotion of the private respondents dated 4/12/2009 and 12/8/2014, except respond number 13, that is D. Suresh, have been given effect to. At this distant point of time, we deem it appropriate to pass the following directions. Accordingly, the respondent authorities are directed to prepare a fresh seniority list, placing the appellants in their respective places by giving them notional promotion without any consequential financial benefits. It is made clear that the private respondents and other incumbents who have already been promoted, except the respondent number 13, will not be reverted back, but they be placed in appropriate positions in fresh seniority list in terms of this direction.
Obliged.
In item number 17.
1 minute.
Okay.
Yes.
In item number 17, I
Late April 27.
yes, 27. I could not send the request 2 days prior for the VC link. I have sent the request now. Can it be allowed me? But my senior will appear from Delhi. So the VC link can be given. I'm praying for a VC link in this case.
VC link.
VC link. I've sent the request today in the morning, but the guideline says
Who's
that
your senior?
Mr. N. Kohli from Delhi.
Okay.
Too late.
Okay.
No. All right.
May I please, I beg to mention item 5, my lord. This case is pertinent to single bench, wrongly listed before the division bench.
Let us see this. What is this matter about?
We have challenged a notification, my lord.
Hmm?
We have challenged a notification, not the rule, my lord. Notification governing the procedure for promotion to the post of headmaster in upper primary school. This is not the rule.
Single bench matter.
Single bench, my lord. Civil bench.
Please before the appropriate bench in as per roster.
Next week, my lord.
On 7th.
May I please, Lordship? Beg to state for item number 19, senior is out of town. So kindly the matter be listed after a week. We have taken the consent of the
Who's your senior?
with D. Sharma.
For the respondent.
Oh, yes.
Have you taken the
Yes,
consent
yes, Lordship.
from the petitioner?
Yes, Lordship.
On request made on behalf of Mr. D. Sharma, Learned Counsel, for the respondent number,
Lordship.
for the respondents,
Respondents, yes.
list after 1 week.
Obliged.
May I please? I beg to mention item number 8, my lord.
Hmm.
I need to, I'm for a respondent number 6, my lord. I need to file one affidavit in position, my lord. So kindly 1 week may be given to file the affidavit, my lord. I have taken the consent from the other.
You wait for your turn. That one.
Yes.
But I'm praying for listing of an urgent motion matter pertaining to the Surface Act, Manoj. There is an urgency in the matter. May it come up on Monday, Manoj? I filed it yesterday.
What is the urgency?
The possession notice is likely to be issued any day, Manoj, and the symbolic position might be taken. And the demand notice was issued in the name of a dead person.
Okay.
Obliged.
I beg to mention a matter for listing on Monday or Tuesday, my lord. It is a matter of 2021, my lord, and it was last listed on 15th of May 2023. It is in the hearing list, my lord, but today that expires, my lord. So if your lordship kindly
What
allow
expires?
the hearing list, my lord, the present hearing list.
Hmm.
So if your lordship may kindly allow listing on Monday or Tuesday.
8.
8.
Hmm.
Can it be Tuesday, my lord, because some outstation council will.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 15 and 16. Lordship, my senior is not well. Matter may adjourn for.
Who's your senior?
Jai Borbija.
Okay, and request Madam
And fix after 1 week, ma'am.
Appellant list the matter after 1 week.
Yes, ma'am.
Separate orders.
May I please, Your Lordship, my lord? May I pray for listing of an IA, my lord,
Hmm.
that we have filed in the month of December, my lord,
Hmm.
on the 8th of this month, my lord, next Thursday, my lord.
May I please, Your Lordship?
Hmm.
Lordship, I beg to mention item 6 of the daily list, Your Lordship. We have
Yeah.
calculated the adjournment
Hmm.
request also yesterday.
Hmm.
Lordship, herein we are to file one more affidavit. A reply to the respondent number 2. So kindly, this matter may be listed after 4 weeks, Your Lordship.
Who's your senior?
MSD goes, I'm appearing on her behalf.
On request Madam MSD Ghosh, learning counsel for the petitioner, list after 4 weeks.
Relatively obliged, Your Lord.
My lord, I beg to mention for listing of one writ appeal, my lord, for hearing list, my lord. That was last listed on 5/12, my lord. One contempt proceeding is also going on against that impugn order. Any date next week?
13.
13, my lord.
May I please, Lordship, item number 12, maybe pass over that day.
Hmm?
Item number 12.
What do you want? What do you want?
Pass over the list.
You are appealing for? You are appealing for?
Lordship, pass over the date.
You are appealing for
Appearing for M. Islam,
appellant.
petitioner. Yes, my lord.
On request Madam behalf of M. Islam, learning counsel for the appellant, list after 1 week.
Item 1 for motion.
May it please your lordship. My lord, this is the PL aggrieved by the petitioner or the local resident of the, my lord, Sonapur, my lord. Samatapur village, my lord. My lord, they are aggrieved by the manufacturing unit as proposed by my lord, the respondent number 7, where my lord, they are taken steps for establishment of cement factory, my lord. In this area, my lord, already there is a cement factory by Star Cement, my lord, and there is a big industry also, my lord. Already this side is, my lord, highly polluted, my lord, become. And now if this unit is again established, my lord, the local people are, my lord, suffering. And accordingly, my lord, they have submitted representation. Lordship, I will take the representation, my lord. Lordship may kindly see page 55. A detailed representation filed by the villagers, my lord, how they are suffering, my lord, due to the pollution of that area, my lord. May I read, my lord, this representation, my lord?
Not necessary.
Lordship. And my lord, in this respect, my lord, Lordship may kindly see page 52, my lord. They are also aggrieved by this, my lord, because there is a public hearing, my lord. In the public hearing, my lord, they could not, my lord, able to, my lord, place their, my lord, grievance, my lord. But they have, my lord, by some peoples and conducted the meeting. But the what was the outcome of the meeting, my lord? These people are not known, my lord. Lordship may kindly see page 25, my lord. As per, my lord, your notification, my lord. May I read, my lord, this? Page 52, my lord.
Page?
52, my lord.
Yes.
Member Secretary, Assam State Pollution Control Board, Bamuni Madam, my lord. Subject. Request for conducting public hearing of project establishment of 300 TDP BSK clinker manufacturing unit and 500 TPD cement manufacturing unit at village Chamata Pathar, Tahsil Sanapur, District Kamrup Metro, Assam by Daibik Cement Manufacturing Private Limited. Reference minus so and so. Dear sir, proposed project is established of 300 TDP so and so VSK vertical shift clinker manufacturing unit and 500 TDP 0.15 MTP cement manufacturing unit at village Samata Pathar, Tahsil Sonapur district, Kamrup Metro, Assam. As per EIA notification, the project falls under category B1 of the item 3B of EIA notification
Yes.
2006.
We have read.
Yes, my lord. Thereafter, my lord, Lordship may kindly see page 54, my lord. A public notice was issued, my here for hearing, my lord. And date was fixed on, my lord, 25/8/2023, my lord. And as per this, my lord, a meeting was also held, my lord. But this was not, my lord, held as per, my lord, required, which is public, wide publication is required, my lord. But, my lord, they have conducted the meeting, my lord, taking some people, selected people, my lord, due to their vested interest, my lord. And thereafter, it is submitted before the, my lord, Pollution Control Board for clearance certificate, my lord. And we have categorically stated that, my lord, Lordship may kindly see para 8 of my petition, my lord, page 10, my lord.
This public hearing notice was given in the newspaper, isn't it?
Yes, my lord.
Then,
It was given, my lord.
then,
But it, this was not, my lord,
it
not
was
so
published,
public.
it was published in the newspaper.
Yes, my lord, that is,
Then
we
what
have
was-
collected it from, my lord, online, my lord.
What online?
This notice, my lord, these people are also not aware of the, my lord, this publication, my lord.
How can you say you're not aware
But-
when it is published in the newspaper?
But thereafter, my lord, they have submitted a representation, my lord. On 28, my lord, it was then this representation was also filed, my lord, but they have not, my lord, given any response till today, my lord. So, my lord, my humble prayer at this stage, my lord. Lordship may kindly see on 24/8/2023, they have received the, my lord, my representation, my lord.
When?
Before page 55, my lord. Pollution Control Board of Assam, my lord.
You are not agreed with the establishment of the other cement factories?
Already there, my lord, there is his protest also there, my lord. By Star Cement Factory, my lord. Already there is factory, my lord. But this was additional by the another company, my lord.
So you are not agreed with the establishment of the other cement factories? Except this one?
But they have already established it earlier, man. We, my lord, submitted complaint before the authorities, my lord. Here also we mentioned, my lord. And if it is one additional, my lord, this is the big cement company, my lord. Another company, my lord. So, my lord, huge, my lord, pollution is there, my lord. My lord, Lordship has no, my lord, one orange, my lord, it is Sonapur. Now it becomes very, my lord, small in size, my lord. There also, my lord, Erakanat, nothing. The fertility of the land is totally going to destroy it. And the water level, my lord, which is decreasing, temperature rising, my lord, in that area, my lord. When we have this side, my lord, we have seen, my lord.
Yes.
Except so far, the petitioner, says to have represented 10 persons. Is he a registered society to assail the cause?
What is the
He's-
public, my lord?
Yes, he's the public. He says to be the public, but I don't understand where is the locus. He have failed to explain.
My lord,
in
it's
the
a PIL,
first
my
two
lord.
paragraph. Yes.
Any public can.
And that apart, going to the merit of the case, in fact, Lordship, right now I have received an instruction which says that already the public hearing has been done as per the due mandate procedure of this 2006 notification, and public were present. And finally, the Ministry of Environment and Forest has given the environmental clearance, which is also a mandatory requirement. Then finally, the Pollution Control Board has given the consent to establish to the industry. All the due process has been adopted and it has been done. And the last environment clearance from the Ministry of Environment and Forest has been granted on 5th of January 2024. So this is what my instruction says. In fact, I have already got a set of the detailed letters which has been represented.
My lord, my grievance has not been considered because I have filed the representation before the public hearing, my lord. And my lord, my prayer is that, my lord, this may be, my lord, lordship may direct, my lord, for a inquiry by an independent authority, my lord. Because
what?
my lord, the people who are suffering, my lord, is a, my lord, very, my lord,
Whom are you representing?
these are the people of the local people of the locality, my lord. They are suffering. They are the sufferer, my lord. And my learned friend is questioning the locus, my lord.
It's a proximity.
Public. It is a public.
Public sector.
No, if you are really concerned about the pollution,
Lordship.
why not agreed by the other established industry?
My lord,
Like
when,
Star Cement.
my lord, earlier many complaint was filed against that also, my lord. But subsequently it was. Now it's a additional, my lord.
Additional has been done as per the rules and procedure.
My lord. So if one thereafter one, my lord, it will destroy the whole environment, my lord. And it's that's why we are
Public hearing
the
was done.
we are concerned, my lord. We submitted, my lord, that was not considered. Our grievance has not been considered, my lord. And so, my lord, if there is an independent inquiry, my lord, it will reveal everything, my lord, by my lord, competent, my lord, health officer, what people are suffering, my lord.
So this respondent number 7 is yet to be established.
Lordship.
But your orange and other fruits become thin or small.
Yes, my
Due
lord.
to the industry is already running.
Yes,
which you
ma'am.
are not agreed.
Yes, my lord.
Like
We
this Star Cement. Where's the party here? Where's the Star Cement?
My lord, because of that cement
appears
also,
not a
and
pro-
as well as now that factory also, my lord.
It's a proxy of
No,
the
my
Star Cement or the other factories already established.
So, my lord, for the public interest, my lord, Article 21 is there, my lord.
No, you
But-
said this orange become small because of this industry.
Yeah, due to
And
politics.
respondent 7 is yet to be established. And you are not agreed by the industries who's running, who's led to, I mean,
My lord, we have stated in our petition, my lord.
no, stating is something
No,
different. You have to
my lord,
make them a party.
if area will, this is the area, limited area, my lord.
Appears to be you are on behalf of these established factories.
No, my lord. We are the people of the local. My lord, we stated this, my lord.
Common people.
Common people, my lord. On that particular area, my lord. We are not proxy of anyone, my lord.
If any step taken to.
My lord, at this is said, lordship may kindly take the cognizance of this, my lord. Otherwise, my lord, because, my lord, all those other, my lords are the, my lord, they are the vested interest, my lord. Factory is there, my lord. And they are trying to establish another factory, my lord. But people who are the actual sufferer, my lord. And in this, their report, my lord, they stated some positive and negative also, my lord. Their employment will be, my lord, like this. But, my lord, so far, my the health, my lord, and the other.
You take appropriate instructions and come back.
I have it. I just put print only one set. If at all lordship would like to peruse this one. This is the environment clearance letter which has been issued by the State Environment Impact Assessment Authority after due process. And the parameters that has been set forth by the to the industry to comply with.
Where's the environment clearance? This is a communication from the respondent 7 only.
There, on last page, Lordship would see the State Environment Impact Assessment Authority members.
Last page.
Yes, the signed page. Third last. In fact, the respondent number 2, who is the State Environment Impact Assessment Authority, the Government of India, so even they would be in a position to apprise the court as regard the present status.
The respond number 2.
Yes,
You are appealing for?
I'm appearing for the Pollution Control Board, respond number 3.
Who appears for respond number 2?
Union. Minister of Environment and Forest Climate.
Forest.
Government of India, yes. Yeah. Union of-
Have you served copies?
Oh, yes, my lord. We have
Union
some
of
problem,
India.
my lord. Because this is my lord, the state of Assam, my lord. Secretary Environment and Forest Department, Dispur, Guwahati state. Assam.
Someone.
Respond number 2.
Yes.
It is Government of India, they have themselves written the address here. The Ministry of Environment and Forest is under the Union Government.
Okay.
Do you know what to keep?
No, here office to
Bamuni madam,
no, there is a communication here.
no, that
Can-
is the wrong address he has been addressing. There is
No.
no Bamuni madam address here.
That's page 33, my lord, the State Environment Impact Assessment Authority, Assam, Ministry of Environment, Forest and Climate, change, Government of India, Bamuni Guwahati 27810. Every unit, page my lord, 33, my lord. Is a communication, my lord.
Government of India, Union Government will represent, not me.
Oh, no. But address is like this, my lord, it is stated. In page 33, communication original is page 36, my lord.
And have you served a copy of the union?
Uh,
Where's the Union of India?
Union of India has, cause list reflects their name.
Hmm.
Arkadev Chaudhary may, we may call him. In the meantime, Lordship may take out the matter.
Call him.
okay.
Pick up later on.
May please, your lordship. Lordship, petitioner, if your lordship had taken a loan from the respondent bank, and thereafter he, because of certain global pandemic and other issues, he could not recover. Thereafter, lordship, bank
How
has
much, what loan you took
business loan, your honor, your lordships.
amounting to?
Much amount? 85 lakhs, around 85 lakhs rupees. And he has been regularly paying the EMIs, lordship. And subsequently, because of that, he is the owner of a bike dealer. And the BS4 engine has been stopped, and thereafter BS6 engine has been introduced. For that, he had a loss of near about 15 lakhs. That is the category stated. And my only grievance is that, your honor, your lordships, that the deputy, the district commissioner had issued a letter, issued a order stating that, which is page 16, annexure B, whereby the taking over of possession of my property has been ordered to be taken. But your lordships, before taking over of possessions, as per section 13, a notice was to be issued to me.
Where's that notice?
No notice was issued. Notice was issued to me in the year 2021. Thereafter, the petitioner approached the respondent bank, and the respondent bank also stated that if you pay us the amount, we will not proceed further. Accordingly, the petitioner also deposited some amount, and thereafter a DRT proceeding has been filed by the respondent bank again for recovery of the loan for an attachment of other properties. The section 13(3)(a) has not been complied, along with section
I think they have an alternative forum.
13(4).
They have
D.
an alternative forum. They should approach the DRD.
At least
You have approached the DRT.
No, bank has approached the DRT. That is separate proceeding. That is for recovery of my loan amount. That is still pending. And thereafter, they have approached the deputy commissioner by filing an application to take over the position of my scheduled property.
Where is that?
Sorry, Lordship.
Where is that?
Lordship will find the order at page 16. That application I could not obtain in the order itself. It has been stated by the deputy commissioner, Lordship. Seen and peruse the application of the authorized officer of and chief manager Canara Bank Sipsagar for taking over position of the secured assets of Masten Soikia, Regina Begum, so and so, of the mortgage land and building area, so 1 bigha, so and so, lag number Iman under section 14 of the Service Act. In view of the above, Sri so and so Circle Officer Nazira Revenue Circle come Executive Magistrate has hereby reputed to maintain the law and order during taking over position of the mortgage of properties. Lordship. And furthermore, Lordship, that before issuing this letter, the order, the Respondent Bank or the state authority should have intimated about the outstanding amount so that the petitioner can deposit the amount, but that has not been done.
What is page 17?
Page 17, the petitioner has, after getting this order, the petitioner has submitted an application before the branch officer, but till that they had not acted upon it, Lordship. As per section 13(3)(a), they should have acted upon it within a period of 15 days. Yes, sir.
Have you taken resort to section 17?
No, Lordship.
Why?
Because, Lordship, the order.
Here in your page 17, annexure C.
Yes, Lordship.
I don't know who has written this, but it says no date has been decided.
Yes, Lordship. Lordship, that is the difficulty. If no date is decided, Lordship, then how can I can ascertain to till when I have to vacate the position? And Lordship, moreover the amount has also been not stated in the order and the date of taking over of a position. And they have not issued the physical symbolic position notice to the petitioner.
So they will issue the notice.
Lordship, before that has to be done under section 13 before taking the permission from the district commissioner, Lordship, but that has not been done.
See, they'll have to issue a symbolic notice, isn't it? Have that been done?
Sorry, Lordship.
That has been done. That symbolic notice has been issued.
That has been done in the year 2021. In the year 2021. And as per section, Lordship, it is to be the application is to be made within 60 days.
On what basis do we interfere?
Lordship,
there's no date given. Nothing here. It says no date has been decided. Yes, on date. However, after getting our approval, we will take the physical possession of the property shortly.
Lordship, that is the difficulty, Lordship. That is why.
So once they fix the date, they'll issue the notice.
Lordship, they, as per my information, lordship, they will not issue any notice because as per their statements, they have issued the notice in the year 2021. So they are stick to that only. And in the order passed by the Honorable District Commissioner lordship, there is no date and no amount has been specified so that the petitioner can approach the respondent and pay the amount.
We issue notice that. Let us see, we'll issue notice. What, Mr.?
S.M. Krishna Trail.
Let me counsel for the petitioner, issue notice. Petitioner to take steps for serving of notice. Who appears for the state of Assam? Mr. D.K. Sharma.
My lord, here, my lord, in response number 1, my learned friend did not mention the department, my lord, only commissioner and secretary. Whose department, my lord? Okay, my lord, for 1, my lord. 2, 3, and 4 is all right.
Who is respondent number 1?
Respondent number 1 is commission.
One department to me.
You.
Lordship, then,
rectify,
Lordship,
you withdraw, rectify again.
Lordship, let it come on next week, Lordship.
For what? You withdraw, rectify your petition and come back. From the cost title itself, all your writ petition is defective.
And one more thing I would like to point out, my lord, his petition is itself, my lord, is a premature. Because, my lord, they prefer a representation before the bank authority. And bank authority on endorsement, my lord.
That I've seen, that's why I was questioning him.
And so far, my lord, district magistrate order is concerned, my lord, circle officer was directed to take, my lord, look into the law and order situation when, my lord, physical possession will be taken up.
Yes. What do you want?
Let me take up, let me take the instruction from my client lordship once.
Okay, on request made by Mr. Spencer and the counsel for petitioner, list the matter after 1 week. Item 1.
My lord.
Yes, Diane,
Yes, my lord.
you take instructions and come back.
Yes, my lord.
For Geotin and the counsel for the petitioner. MS A guy. Is it G A guy?
A Gayan.
A guy, no, not CGC. You are CGC?
CGC.
Shall take instructions. When do you want?
My lord, it is. We can. My lord, 50. 50.
1 5.
1 5, my lord.
Please not 15.
Must have.
Obligers.
Extra copy maybe, sir.
I'll serve, man.
Item 3.
May it please your lordship.
Yes.
My lord, here we are assailing a order passed by the deity rejecting my prayer for staying the operation of an order passed by the district magistrate under section 14 of the SARFAESI Act. Now, kindly see this SARFAESI Act, my lord. Kindly see section 14 first.
Yes.
And then, my lord, we will place this impugn order in the light of section 14, my lord.
Yes.
Where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor, under the provision of this act, the secured creditor may, for the purpose of taking possession or control of such secured asset, request in writing the chief metropolitan magistrate or the district magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found to take possession thereof, and the chief metropolitan magistrate of the case may be the district magistrate shall, on such requests being made to him, take possession of the asset and documents and forward such asset. Now, can we see the proviso? Provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that. Now there are subclause 1 to 9, certain declaration. Now kindly see this next proviso, madam. Provided further, on receipt of the affidavit made from authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured asset within so and so date. I will not read further, madam. Well, this proviso was not initially there. Kindly appreciate it under at section 14, the DM does not exercise any adjudicatory function. As a borrower at that stage, I have no right to be heard or even for a notice. So it's a very stringent power given to the district magistrate to take physical possession of my property. And therefore, earlier there was no checks and balances against any arbitrary probable exercise of power, arbitrary exercise of power. And therefore, my lord, to protect the interest of the borrower, this proviso was brought into statute book by way of an amendment in 2013. Now, post-amendment, the requirement is the application must be accompanied by an affidavit by the authorized officer, making certain declaration is provided in the subclause 1 to 9. Further, this order of the district magistrate must show satisfaction, indicate satisfaction regarding compliance of this affidavit and its content. That is the mandate, and it's a mandatory provision. Now, kindly see my lord, this impugn order. Can you see this impugn order? Page 61. That's the letter written by the bank to invoke section 14. Lots will find DM permission under section 14 of SURFACE Act, petitioner so and so. Then these are the names of the borrower, my lord. Then with reference to the above, we confirm that we have initiated SURFACE action against the borrower guarantor as per bank's laid down instruction. Notice under section 13.2 and 13.4 and possession notice are published in the newspaper within the stipulated time. This is for your information and needful action. It indicated nothing about affidavit as contemplated by the proviso of subsection 1 of section 14. Now see this impugn order, my lord. Page 62, the next page. The circle officer and executive magistrate Karimganj is hereby entrusted to provide necessary administrative assistance to the authorized officer for on behalf of the State Bank of India, so and so, in securing possession of the secured asset as detailed below. Now there's a list of my secured asset has been provided. Now please come to page 64, man. The last two paragraphs of page 64. This is ordered on receipt of request from authorized officer for and on behalf of State Bank of India, so and so. This is expressly and categorically stated by the said holder of the secured asset that all possible means for recovery of the dues has been exhausted under section 13.2 of the SURFACE Act. An acknowledgement of by borrowers and guarantor as on demand. The borrower has not deposited any amount servicing of SURFACE notice under section so and so on dated so and so. So it is duty of the holder of the secured asset to complete all formalities during this time, taking over the secured asset and so and so. It goes on. So this is the order. This order, my lord, nowhere indicated about this affidavit and this 9 declaration. That has to be there. There is nothing to show about his satisfaction, application of mind to the contents of the affidavit and its declaration as contemplated by the provider, by the proviso appended to, my lord, subsection 1 of section 14. There is no application of mind. It's clearly, my lord, not in conformity to the mandate of 14. Absolutely no clear. No affidavit, which is a must, because that was brought in by an amendment to protect the interest of the borrower.
Yes.
Not only that, my lord, our just in support of that, my lord, I'm relying on 2 decisions of the Andhra Pradesh Division Bench High Court, High Court Division Bench order, my lord. The Division Bench judgment of Andhra Pradesh High Court, my lord. Kindly come to page 3, my lord. Internal page 3, last paragraph from page 3. Perusal of the amended provision of section 14 of the Act of 2002 reflects that after 15/1/2013, a secured creditor who seeks to take recourses to the powers of the Chief Metropolitan Magistrate or the District Magistrate thereunder to take possession of the secured asset must file an affidavit duly affirmed by the authorized officer of the secured creditor, setting out the particulars detailed in subclause 1 to 9 of clause A, B of subsection 1 of section 14 of the Act of 2002. The second proviso to section 14 of the Act of 2002 requires the district magistrate or the chief metropolitan magistrate, as the case may be, to satisfy himself as to the contents of the affidavit he received from the authorized officer and thereafter pass suitable orders. Dealing with this provision in Standard Chartered Bank versus V. Noble Kumar, 2013, 9 SCC 620, the Supreme Court made it clear that after the amendment of section 14 of the Act of 2002, the magistrate concerned can pass suitable orders for taking possession of the assured asset only after being satisfied with the contents of the affidavit. And in this regard, he would have to record his satisfaction. No doubt, recording of satisfaction in the terms of the aforestated provision may not require detailed reasoning being set out by the magistrate concerned, but there must at least be evidence of application of mind by the magistrate to the contents of the affidavit to satisfy himself that the statutory requirement have been duly complied with. The impugned proceeding dated so-and-so fall woefully short insofar as the requirement is concerned. There is not even a mention of any affidavit having been filed by the authorized officer of the secured creditor, the fourth respondent herein, much less any satisfaction of the district magistrate with regard to the contents thereof. There also, my lord, the impugned order did not indicate anything about the affidavit and also application of mind, as in our case, my lord. As in our case.
Third minister
And not.
and not the council. Issue notice. Petitioner to take steps for service of notice on the respondents 1 and 2 by registered post.
Right.
By registered post ID within 2 weeks, 1 week from today. List the matter after 4 weeks. in the interim. Who is that order?
My lord, I am praying for staying of this operation of this impugn order, my lord.
The DM's order,
My lord,
the order dated
it was dated, my lord,
31st August
31st of August 2023.
2023. The, in the interim, the impugned order dated 31st August 2023, issued by the
District Magistrate.
District Magistrate Karimganj.
Much obliged.
Item 4.
My lord, in this matter, the petitioner before this honorable court is the bank. My lord, the respondent number 3 and 4 has taken some credit facility from the petitioner bank and subsequently defaulted, and their accounts become NPA. And since their account become NPA, we have taken surface actions, started surface actions. And during the proceeding of the surface actions under section 14, we approached the deputy commissioner for passing of the order under section 14. And that under section 14, the deputy commissioner also issued one order that is in the page number 23. On the basis of this order, we tried to take possession of the property on 28/12/2023. But during the time of taking the physical possession of the property, the authorized official, my lord, in this order, the deputy commissioner authorized one executive magistrate to help in the taking of the possession. But he denied to help to the petitioner bank, since this order is specifically to maintain the law and order situation, my lord. My lord, may I kindly see the section 14, my lord, of the surface. Married. Where the possession of the any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provision of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the chief metropolitan magistrate or the district magistrate within those whose jurisdictions any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate, or as the case may be, the district magistrate shall, on request being made to, here is the main point, my lord, to take possession of such asset. So, my lord, district magistrate has to take the possession of the property, to take possession of such asset and forward such asset. A is taking possession of the property by the district magistrate, B is the forward this property to the bank. But in this order, my lord, kindly come to page number 23 of my petition, my lord. The order passed by the deputy magistrate, seen and pursued the letter received for the authorized official, Bank of Baroda, such and such, letter dated such and such, against the borrower such and such. Accordingly, such and such persons is hereby deputed to oversee law and order only during taking over the possession of the following secured asset by authority of the said bank as per the provision of the Surface Act 2002. My lord, in this order, the person who is subsequently authorized by the deputy magistrate is only authorized to see the law and order situation. But the provision says they have to take the possession of the property and handed over this property to the bank. So, my lord, subsequently we have submitted one representation before the deputy magistrate also in this respect, and that representation is still pending, not disposal. My lord, section 14 is the time-bound proceeding. So, my lord, that's why we are before the honorable court.
Yes.
My lord, with a time frame that the reputation may be disposed of, then direction can be passed, madam.
In view of the section 14.
No, thank you for. Since my lord, the representation is pending, their grievance is there.
Yes, ma'am.
Let the
Let the representatives may be
according to
disposed
the
of,
law, my lord.
considering the section 14, ma'am.
Heard Mr.
B. Sharma.
B. Sharma, learned counsel for the petitioner. Also heard Mr. Endas,
For 2 and 3, my lord.
learned government advocate. For the respondents, 2 and 3. Stop. Para. The petitioner before this court is a public sector undertaking, bank, I, Bank of Baroda. Stop. The
Powerful representative party. Deputy commissioner is not a party. District.
Is it Bank of Baroda or Vijaya Bank?
It's a Bank of Baroda. Earlier it was actually BJI Bank, madam. Now it's merged with the Bank of.
The respondent number 3 and 4, isn't it? Or 3?
3, ma'am.
Respondent number 3. Avail working capital.
No, my lord, it's respondent number 3 and 4.
Correct. 3 and 4. Avail working capital limit of rupees 25 lakhs from the erstwhile Vijaya Bank.
As will be.
From the erstwhile Vijaya Bank. Now Bank of Baroda. No, cancel it. The respond number 3. Avail working capital limit of rupees 25 lakhs from the erstwhile Vijaya Bank, now Bank of Baroda.
Respondent number 3, my lord,
And
here
the-
is the executive magistrate.
And the respondent number 4 stood as guarantor to the said loan. Stop it. As the respondents 3 and 4 failed to repay the loan amount as per the terms and conditions of the sanction, the loan accounts of the respondents were declared as non-performing assets within bracket NPA. Stop. Thereafter, the petitioner bank initiated proceedings under the Surface Act 2002, 2002 to recover its lawful dues. Stop. The petitioner bank accordingly approached the concerned district magistrate for passing necessary directions under section 14 of the Surface Act of 2002 for taking possession of secured assets and documents relating thereto. Stop. Accordingly, the additional district magistrate, Kamrup Metropolitan District, Guwahati, passed in order on 28/11/2023, deputing one executive magistrate, Kamrup Metro, to oversee law and order, to oversee the law and order only during taking over the possession of the secure assets of the respondents 3 and 4 by the bank as per provisions of the Surface Act of 2000. Stop. When was the date?
It was actually on 28/12/2023 we approved.
Accordingly, comma, on 28/12/2023, when the petitioner bank tried to take possession of the secure assets of the respondents 3 and 4, the deputed executive magistrate, Kamrup Metro, failed to cooperate with the petitioner bank on the ground that the executive magistrate was deputed only to oversee law and order situation. Stop. Being aggrieved. Where's your
Representation, page number 24, man.
the petitioner bank through whom was this made?
Madam, we have sent through the branch manager to the district magistrate.
Through the branch manager. Made a representation on 4/1/2024 before the district magistrate Kamrup within bracket and Guwahati. To take appropriate steps in the matter. Stop. However, comma, said representation is yet to be considered and disposed of by the district magistrate Kamrup within bracket M till date. Stop. Para. In view of the discussions made here, comma, the suit petition is disposed of, directing the district magistrate Kamrup within bracket M Guwahati to dispose of the representation filed by the petitioner bank on 4/1/2024 within a period of 2 weeks. 2 weeks from the date of receipt of a copy of the order of this court. Stop.
According to law, man, that may be
In accordance with law. With the above observations and directions to petition.
Diploma.
Item 7 for admission.
Your lordship, I am appearing for your lordship missing autonomous council. I was directed to take instruction, your lordship. I have received instruction, your lordship. I may be allowed 10 days time to file an affidavit based on
My lord.
that.
Heard Mr. Yamanda, Leonard, Standing Counsel, Guwahati High Court. Mr. S. Butterfield, Leonard, Standing Counsel, Missing Autonomous Council, submits that he has received instructions and prays for 2 weeks time
My lord.
to file affidavit. Stop. Grace or not? You want a date fix or after 2 weeks? List after 2 weeks.
My lord.
Diploma.
Item 8.
Yeah, please, your lordship. Lordship, on the last occasion, respondent number 6 took time to file the affidavit in opposition.
So,
My lord, I had prepared the affidavit, but the signing authority, the registrar of the institute, he was on leave. So kindly 1 week time may be given, so I can file the affidavit.
Lordship, just one point I would like to raise, your lordship. The respondent number 6 is the director of the institute. And during the writ petition proceedings, the affidavit was signed by the director. So will it be correct for the registrar to sign the affidavit on this occasion? Registrar is on leave, it's a fact. He is on leave till today. From Monday, he will be back.
let the director file the affidavit.
Yes, lordship.
Can be filed, my lord, but since the Kalatnama has been signed by the registrar on behalf of the director. Since
It doesn't, whatever it is, register is appearing on behalf of director. He's
If no discrepancy occurs later on, then no problem, your lordship.
heard Mr.
Mr. A. Khan on behalf of Mr. F. Khan.
A. Khan, learned counsel appearing on behalf of Mr. F. Khan. Learned counsel for the appellants. Stop. Mr.
D. Gugoi.
D. Gugoi, learned standing counsel, learned counsel for the respond number 6. Is allowed, how much time?
1 week may be given.
It's allowed another week's time to file contract.
Lordship, a date may be fixed, your lordship.
This, the matter on 12th.
Obliged, your lordship.
Item 9.
Yes.
May your lordship. My lord, we have filed this writ appeal against the impugned order that lordship may kindly see page 73. Here.
You are the appellant.
Yes.
You should be here. Yes, I'm not sure. He should be here.
Oh, I is not. Sorry. Sorry, madam.
Okay, now.
I is there. Sorry. My lord, in this case, since the year 1994, the appellants are running a school by the name and style of Gunaipani ME Madrasa. And the private respondents, who are numbering 3, they were ousted from that school long back. After their ousting, they started another school by the same name. And by managing the departmental officers, they also ultimately got their schools provincialized. All the provincialized order,
There's no evidence.
I am showing, please wait, I will show how things has happened. Now, lordship may kindly see page 26 of the writ appeal. Here, this is the initial proceeding of opening the ME Madrasa. It was held on 10/9/1994. Today, on 10/9/1994 at about 8 a.m., a general meeting is held in the premises of Gunaipani Gunestari LP School as per invitation of one Tamaj Ali, the village headman of Gunaipani village, with other local people, farmers, adult educated boys and girls, and local parents, guardians to establish a ME Madrasa at the village, since there is no facility for middle education in this village. One Tamaj Ali village headman presided over the meeting. In that meeting, following resolutions have been taken unanimously. Signature of the public present here, lordship would see, my name is there Abul Hussain, who is the headmaster of the ME Madrasa. So, on 10/9/1994, the appellant number 2, who is the headmaster, he is present. He is the founder headmaster. And these private respondents, they are absent. Now, lordship would see, this is the proceeding of opening proceeding. Then lordship would kindly see, after taking the opening proceedings of the school, they wrote letter to the government and government issued permission. Lordship now kindly see page 29. To the district elementary education Dhubri, opening permission. With reference to above, I have directed request you kindly to furnish detailed inspection report along with other required information in respect of Gunaipani ME Madrasa in the district of Dhubri for consideration. So, this is the letter of the government issued to the district elementary education officer, Dhubri, and ultimately lordship would kindly see the instruction note, page 30. Here, lordship would see date of inspection 20 top, page 30 top. 20/11/1997, name of the school Gunaipani Madrasa, address Gunaipani, so and so, so and so. It is established on 10/9/1994, lordship, that very day when the proceeding was started. So, Abul Hussain headmaster, here the Abul Hussain is the headmaster, who is the appellant number 2 in this writ appeal. So, this is a remarks, lordship would say, page 13, bottom. The school is situated at the remote area of Assam Meghalaya border. Maximum people belongs to poor cultivator, fishermen, and labor of Hindu and Muslim community. The area is necessarily backward. The area is surrounded by, at the east, Porwa Bill, west Bauluri village, Bauluri Bill, south Jinjiram River, and north Kurmi Porwa Bill. Due to natural barrier, a middle school is required in the locality. So, my lord, this was the inspection report of the inspector, that is the DO, because he was asked and he said this, my lord. Here, lordship would see the name of the present appellant number 2, who is the headmaster. His name also appears in the top. Then lordship would kindly see page 36. Here, my lord, there is a question. In the long run, due to some objections raised by other surrounding schools, it was proposed by the SMC of Gunaipur Madrasa that the school should be shifted to village Bauluri, nearby village Bauluri. So in this regard, they wrote a letter to the authority, and authority, against the authority wrote a letter to DO, that kindly see page 37, from Moniruddin Ahmed, Block Elementary Education Officer, South Chalmara, to the District Elementary Education Officer, Dhubri, shifting of Gunaipani Madrasa to the actual land. With reference to the subject cited above, I have the honor to inform you that Gunaipani Madrasa building situated at recordless land near so-and-so, that is at Gunaipani, that SMC adopted resolution to shifting madrasa building in its own land at Bauluri. At Bauluri, that may be seen page 37A. It is not so clear, that's why we have kept it vacant. So, SMC adopted resolution that due to objections of certain nearby schools, the school should be shifted to village Bauluri from Gunaipani. And the same was also inspected by the authority. Then lordship can see page 38. To the circle officer. Circle officer inquiry. Here this letter is written to the circle officer by ADC. With reference to the above, I am including here with a prayer petitions issued from Headmaster Gunaipan Madrasa, village so Bauluri. You are requested to ascertain the existence of the said school and submit report to this end at the earliest for taking further follow-up action. Then, lordship, this report, this letter was responded by the authority, that is the circle officer. Kindly see page 39 now. Submission of inquiry report. Here, lordship would see para 2, 39, para 2. The Gunaipani Madrasa, headed by its headmaster Abul Hussain, was accorded recognition on 29/12/2005, issued by the Joint Director, Elementary Education Assam, vide his office number so-and-so, letter number so-and-so, with effect from 1/1/2005. The Gunaipani Madrasa was shifted to Bauluri village as proposed and directed by the BO, South Chalmara Education Block, vide this is letter number so-and-so. There was none madrasa at Gunaipani village. Then lordship would see para 5. After shifting the Gunaipani madrasa from Gunaipani village to Bauliri village on the land of madrasa, Chanmia has fraudulently, my Chanmia is the private party. Here starts their cunningness. Chanmia has fraudulently been using the name of Gunaipani Madrasa, headed its headmaster Abul Hussain. Gunaipani Madrasa, presently Bauliri village, headed its headmaster Abul Hussain is genuine. Gunaipani Madrasa at Gunaipani village, headed its headmaster Chanmia is fake. Verification list prepared by LR staff functioning at Bauliri village, so and so. My lord, here details all the local people were examined by the this circle officer, and he submitted report, and lastly his opinion he has added page 39A bottom. In my opinion, financial assistance and other benefit of government and any other agency may kindly be provided in respect of Gunaipani Emi Madrasa presently located at Bauliri village as valid madrasa headed by its headmaster Abul Hussain and others. This is submitted for your kind information and further following action. So, Lordship, here Lordship will see this was the report. Not only this report, my Lord, similar report Lordship would kindly see, page 39 also, 39 also same thing is there. Now, again, my Lord, the same thing was again inspected. Now, Lordship kindly see page 41. 41 bottom. Here, my Lord, this letter is written by the Director, Elementary Education to the DO, Dhubri. With reference to the subject cited above, I am directed to request you kindly to verify an authenticity of the listed middle schools under your jurisdiction and submit the report along with a certificate of genuineness within 7 days. So, here, my Lord, our school is in Dhubri district. So, necessarily we came within the purview of this letter. And then, my Lord, this report was submitted by the BO to District Elementary Education Officer. What is his report? Kindly see, my Lord, page 42, serial number 1. Name and address of the madrasa, Gunaipani Emi Madrasa, village Bauluri, post office Chirakuti Bazar, date of establishment 10/9/1994, date of permission 23/12/2005. So all these things, lastly, my Lord, it was certified that school have received government permission and departmental recognition as per office record and functioning properly as per physical verification report. No false statement is done in case of permission and recognition of the school. So, this is the report in my favor. Repeated reports are coming in my favor. Now, Lordship may kindly see page 41. Oh, sorry, 41 I have already read. It will be 42 is also similar thing is there in our favor. Then Lordship kindly see page 44, my Lord. This is the high level inquiry. High level inquiry which was conducted by Joint Secretary to the Government of Assam Secondary Education Department. And it was submitted to the Commissioner and Secretary of the Government of Assam Secondary Education Department. Now, Lordship will kindly see, here's the high level inquiry report. What the report says, Lordship, starting point I am submitting, then I will show the opinion. With above reference and subject, I have the honor to information you that inquiry was conducted by the undersigned and findings are as follows. For conducting the inquiry, the concerned parties, including the education officer, were asked to appear in person for adducing evidence and presenting relevant records in support of the claim and counterclaim. So, Lordship would say all the officers were invited to participate in the inquiry which is going to be conducted by the Joint Secretary. So, they were present, public were present. Then Lordship would say, it is alleged, page 46, second para. It is alleged by Chanmia that Abul Hussain was discharged by his SMC on 30/8/2009, but Abul Hussain denies the allegation, stating that he was discharged by a person of other SMC who was not competent to discharge. Actually, Chanmia made another SMC for his own interest and they discharged me, whereas they have no any connection with this original school. Then Lordship would say, he also states that on the advice of education officers, Polymer, Emi Madrasa, Gunaipani, Pre-Senior Madrasa, Chirakuti, Gao Panchayat and local people, the school was shifted, but in the same name of Gunaipani Emi Madrasa for greater interest of public, which I have already narrated, my Lord. Now, Lordship would say here, page 46 bottom. From the above facts, it comes to the light that Abulhussain, the founder headmaster, in much senior to Chanmia, who claims to have been appointed as headmaster of Gunaipani, these facts have been illuminated in several inquiry reports of the education officer and officers of the district administration and magistrate, file number so-and-so, dated so-and-so. So many letters he has quoted. All these letters are in my favor. Lordship, this is I am compelled to say this has become the profitable eke for the department. So many inquiries for the same school conducted. I don't know why they are not satisfied. One report comes in my favor, they are not. Another comes, they are not satisfied. So kindly share so many letters, madam. Page 47, so many letters reference the joint secretary has given, and then he has come to finding. Kindly see page 47. Bottom. Another two important points come out with the written statement of Chanmia. Dice code bearing number so-and-so was issued during the 2008-9, in which Abulhussain was recorded as the headmaster. Chanmia was appointed on 3/9/2009, that is later issue of dice code. So he is a person who was appointed after dice code was issued. Thereafter he was discharged. So those things are there, my lord. Then Lordship would say, page 48. 48, 47 bottom I am reading again. Chanmia was appointed on 3/9/2009, that is after issue of dice code. So it is clear that dice code number so-and-so is now being misused by Chanmia, manipulating the official records. And thus, the school headed by Chanmia appears to be a fake one. On careful examination of all aspects stated above, I am of the opinion that Gunaipani ME Madrasa headed by Abulhussain is original and genuine. Had it not been the fact how the dice code number so-and-so of 2008 and 9 was issued, stating Abulhussain as the headmaster of Gunaipani ME Madrasa, if Commissioner and Secretary agrees that DE may be directed to stop all financial assistance and other such assistance extended to Gunaipani ME Madrasa headed by Chanmia and take all the corrective measures for taking up the school headed by Abulhussain as genuine one. So, Lordship, this is the finding of the Joint Secretary. Even then, my lord,
Come to the point.
all, not only this, many things are there. Even then, my lord, due to unknown reasons, my lord, this, now kindly see page 57. This is the provincialization order. And
Of your school.
no, this was not done in my favor. That is my grievance. It was provincialized in favor of the other persons. Kindly see page 58, serial number 577. 48. Here, the name of Chanmia, Rakibul Haq, and Rupchan Ali, their names are there. Whereas they are the fake school. All the reports say like this. But ultimately, order was passed in their favor. So we have challenged that. Then thereafter, my lord, what happened? Basis of this letter was that. Now kindly see page 59. Here, so much I don't know under what authority, CRCC. CRCC, my lord, what? A headmaster, he is appointed as CRCC to look few schools. He is below SI. This person, kindly see, it is dated 24/6/2014. Submission of inquiry report of Gunaipani Madrasa village Gunaipani, headmaster Chanmia. He says like this, as per your verbal order, kindly see verbal order. So many written orders are there. A verbal order of DO, DO has submitted report in my favor. Now he finally said that, page 60, kindly see. Therefore, it has come, page 62nd para. Therefore, it has come to my knowledge that Gunaiban Madrasa at village Bauleri headed by abolition is fake school. This is the only report of CRCC, and he's the lowest category of officer. And he came to the school as per Fabulous order, which is no basis. Now he conducted the inquiry on 24/6/2014, page 59, but submitted the report. It appears that he submitted the report on 24/6/2014, but prepared the report on 26/6/2014. That means before preparation, he submitted the letter. He prepared the report on 24/6/2014, page 59. Lordship has seen, but it was submitted by him on 26. He sent this 26/6/2014. So it appears that before 2 days, he has completed the inquiry, and in the inquiry report, my lord, we were never asked to participate, nor it is there in the case that we are asked. So this is the my lord. Then, my lord, we filed a writ petition before the Honorable High Court. That lordship may kindly see page 61. Operative portion, page 65. Here, considering the above facts and matters in the hand, the school Gunaiban Madrasa, which Sanmia is functioning as headmaster, situated at Gunaiban is found to be genuine and eligible for financial assistance and other benefits provided to a government education institution. So this order was passed, page 65. It was passed on 6/12/2017. Page 65 bottom, kindly see. 6/12/2017. But this order was cancelled, was set aside by the Honorable High Court. That lordship may kindly see. Operative portion I am only showing. Page, my lord, 65F bottom. 65F bottom. From the above, this court is of the opinion that the impugned order dated 6/12/2017, that is the order which was passed in favor of Chanmia, issued by respondent number 1, that is the government, suffers from material infirmity, the same being not properly substantiated by materials on record, cannot be held to be valid, and accordingly, the impugned order dated 6/12/2017 is set aside. Accordingly, respondent number 1 is directed to reconsider the matter and to take a fresh decision in terms of the order dated 27/7/15 passed by this court in IA number so and so. So that order was set aside, but ultimately, my lord, on the basis of that was one of the important factor which was taken by the learned single judge at the time of dismissing my petition. Whereas this was already dismissed by a coordinate bench. So the impugned order was passed by the learned single judge against the order of another learned single judge, though there is no appeal. So that is enough to set aside the order. Now, lordship kindly say, again, my lord, again inquiry was started. That lordship may kindly see page 66. Here, this officer says, my lord, in compliance with the Honorable High Court order dated 22/11/2019 in WBC number so and so, Srimati Anuja Bhuya, ACS Deputy Secretary Government of Assam, is hereby appointed as inquiry officer in connection with identity of genuineness of two madrasa. Now, lordship would kindly see, he is the Deputy Secretary. He is the Deputy Secretary, he undertook the inquiry, whereas the report was submitted by Joint Secretary. He is higher officer. Joint Secretary is higher than Deputy Secretary. So, lower rank officer was entrusted to the inquiry when there is a report of the high ranking officer. Lastly, she asked us to produce documents. I produced document, kindly see now page 67. Page 67, 33 documents I have submitted before the inquiry officer. including passbook, bank account, land deed, namjari copy, land possession certificate, Sita map, all the relevant documents of the school I have submitted. But Chanmia instruction report, data of various officers. So those things are there. So these are from the very beginning till the day when the inquiry was conducted. And ultimately, the order was passed, that is page 68, by the authority. Here they have only said CRCC's report. CRCC's report they have taken as the basis for which our genuine school was deprived from the benefit of provincialization, and only on the basis of that and verbal statement of Chanmia, he could not produce any document accepting the report of CRCC and some other fake documents, which were duly inquired into and found that those are fake documents. The order is now passed in favor of the fake school. So that lordship may kindly see page 72, operative portion. Page 72, bottom line. From all this and above, it can be ascertained that Gunaipani Emi Madrasa, situated at village Gunaipani, post office Chirakpeti, education block, South Shalmara, district Dhubri, presently headed by Chanmia, is the original school, and on the basis of its originality, financial assistance was released and provincialization too has been accorded as per Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act. So, Lordship would say, this order we had challenged before the learned single days. Now, thing is this, almost all the 99.9% documents are in your favor, but order is passed in their favor. I do not understand, my lord. I do not understand what is the matter. Now, the LP skill teacher's report is accepted and the commissioner's report is not accepted. And repeated inquiries in my favor. Learned single just passed the impugned order that the order suffers no irregularity. It is very difficult to accept, and more so when, my lord, at the time of dismissing the repetition, learned single just took the order, page 81, kindly see, page 81, says para 16.2. Para 16.2. The order that is 6/12/2017 issued by Commissioner Secretary to the Government of Assam Elementary Education Department. So this order was set aside by the High Court earlier, much earlier. It was pointed out. It is on record. So that was also taken one of the reasons for which the writ petition was dismissed. The government passed order in their favor, whereas that order was set aside by the High Court. So this type of order, my lord, I think this type of order should not be allowed to continue, and repeated departmental orders in such type of cases, I think here Lordship would say there are also various reports that action should be taken against Chanmia. Action should be taken against Chanmia, that I am doing one thing, my lord. Page 56 for a moment, kindly come. Page 56. 56 for a moment. Government is taking the take action against Chanmia. Yes. So many orders are there in our favor, and government has also asked the authority to take action against Chanmia, but all these things are nothing is done, and all on a sudden, their school was provincialized, and my lord, in this manner, since the year 1994, we are suffering, and they are being fake school, are getting financial aid since the year 2009, though the dice code is in our name, and thereafter provincialization benefits after thereafter. Earlier they got financial assistance, then from the day of passing the provincialization order, that is page 57.
Did you challenge this inquiry report
This
of the deputy secretary?
no, deputy secretary's report that is under challenge, yes.
In the writ petition?
In the writ petition, my lord, in the writ petition, that was also under challenge, because on the basis of that, writ petition was filed, challenging that order.
Are you sure?
Yes, my lord,
Where
because
is your writ petition?
yes,
Where is your writ petition? Yes.
my writ petition may be seen. Page
101, my lord, the prayer portion. Page 101, the prayer portion.
101.
85. 85 onwards. My writ petition, 85 onwards.
Provincialization.
Well, at page 99 may be seen, para 13. Page 99, para 13. The petitioners beg to state that so-called inquiry report of the cluster research coordinator dated 26/6/14 and order dated 6/12/2017 are false. As such, being agreed by the petitioners filed another writ petition before the Honorable High Court, file number so-and-so, and the Honorable High Court by an order dated so-and-so disposed of the same with direction to the government to cause inquiry and hear the matter in presence of both the parties. The petitioner submitted the copy of other order before the concerned authority, and after receiving the order, the Deputy Secretary to the Government of Assam issued notice to both the parties on 21/1/21 and asked the concerned parties to appear before the said authority along with all necessary documents fixing the date on so 11/2/21. On the day, petitioner number 2 appeared before the authority, but respondent number 7, Chanmia, did not appear. However, no next date was fixed. The petitioner begs to state that, para 14, when the matter was under process of inquiry in the highest level of the government, suddenly on 4/12/2021, a list was published where it can be seen that posts of respondent number 7, 8, and 9 have been provincialized. Though the earlier high-level inquiry report categorically held that Gunaipani Madrasa headed by petition number 2 is the genuine school.
Come to page 101.
Yes, 101, my lord. Yes, prayer portion. Under the facts and circumstances stated above, it is most strictly prayed that your lordship would be pleased enough to admit this petition, call for records, issue notice upon the respondent to show cause as to why the impugned or provincial order dated so-and-so of the respondent numbers 7, 8, and 9 shall not be cancelled, and in their place the posts of a petitioner shall not be provincialized, and now to show cause as to why appropriate action shall not be taken against the concerned officers for whose initiative the false and fake school teachers posts have been provincialized. Specifically, matter that Deputy Secretary that is not mentioned.
Come to page 83.
Yes.
Read it.
A report has come to the finding that Zunaib madrasa run by the respondent number 7 is the original madrasa. This court does not find any ground to interfere with the said finding. If the petitioner is agreed with the same, he can always approach the civil court, as a writ court is ill-equipped to take evidence. The above being said, the inquiry report, which is annexure A to the affidavit in opposition filed by the respondent number 7 and 9, 7 to 9, has not been put to challenge in its writ petition. The petitioners have only prayed for setting aside the consent order dated 4/2/2021, and for consideration the petitioner, there is no prayer for setting aside the inquiry report. Yes, that is there, my lord. But thing is this, my lord, Lordship, I have a judgment that when কিতাপটা আছে নেকি এই ধৰা কিতাপটা আছে মই লিখি কিতাপটা লৈ আছো ড্ৰয়াৰত মই লিখি কিতাপটা আছে লৈ আহা মানে there is a judgment of the Honorable Supreme Court. Even if there is no law, in the interest of equity, justice, and court should provide substantial justice. That is one thing.
That is a different.
And another judgment, my lord,
We're
is
asking you a pointed question.
it is directly, my lord, I have not prayed for. That is on record.
Yeah.
But thing is, this lordship
What
has.
can we do now? It is only an appellate court.
Then I may be allowed to file an amendment, an additional affidavit.
Where?
Here in the writ appeal. It is a part of writ proceeding, my lord. Writ appeal is also continuation of writ proceeding.
For what reason do you want to file your additional affidavit?
Additional affidavit challenging this to that liberty may be granted. And writ court, a new plea can be raised. Our High Court has so many citations. New plea may be also raised.
Those side issues.
Then kindly fix it tomorrow, my lord. I'll satisfy new plea as well as if even something is not prayed, but it is otherwise on record. I understand.
Tomorrow I'm having my weekend.
Well, I understand your lordship's inquiry. I also admit sometimes it so happens. So many documents. So let it come on Monday, my lord, I think. I will show on regarding new plea, regarding prayer not made for, but otherwise lordship has seen we are the victims of injustices.
Yes. One thing I'll point out, page 77, madam, of the, this is the judgment of the learned single judge. Page 77, paragraph 4 onwards, madam. Being para 3. The fact in brief is that the Gunaipani ME Madrasa run by Chanmia was selected as appropriate school to receive financial assistance from the state government during the session 2010 to 2011. Being aggrieved, the petitioner number 2 filed WPC 805 of 2011 stating that Gunaipani Madrasa run by respondents should have been the appropriate madrasa. 5. This court by order dated 24/10/2011 dismissed WPC 805 of 11. However, it gave liberty to the petitioners to take recourse to appropriate provisions of law to remedy its grievance regarding the question whether the petition number 2's madrasa is the appropriate madrasa to receive financial assistance. As the question required taking of evidence and making of an inquiry, the court held that the remedy for the petitioner number 2 lay in instituting an appropriate suit for declaration, if required for consequential relief of injunction. This court does held that the writ court could not determine disputed question of facts. My lord, what an advice had come from the Honorable Court, my lord, that it is a suit. Now, what does the petitioner do? Due to the dispute between the parties, complaints were filed. The suit is not taken into, is not resorted to. Complaints are filed and a fresh ground for filing a writ petition and approaching this court is again made out. Again, in the year 2023, my lord, this Honorable Court has held, go for a suit. That is where the relief lies. Here it is a writ appeal and now a prayer to include by an affidavit a relief which was not paid for in the writ petition. My lord, it doesn't deserve merit.
My lord,
it is only prolonging the
government should be clear in their submission. All are their documents. They have passed order against their own documents. Now they are testily supporting the illegalities because all their reports are in our favor. They are justifying. My lord, why, in spite of having so many documents, why I shall go to for the suit? That is also my grievance. I have so many documents. If the writ petition can be disposed of, there are so many citations. If the writ petition can be disposed of on the basis of annexed documents, then no need to go to for party cannot be dragged to filing after cases. My lord.
Dispute is whether your school or the school run by that Mia is the original or is the real or the fake one. That's the thing. Can the writ court decide that?
My lord, because on the basis of documents, how they can came to the finding that their school is
You
genuine?
also have documents. They also have documents. Both of you have documents.
But weight of the papers, lordship, kindly see, weight of the papers. So that is
You want it. You want some time. We'll give you time.
On-
Otherwise,
on Monday.
We'll dismiss this
no on that is on Monday. I will satisfy on those points.
on request made by me, Mahmoud, and the council for the issue. List on 12th. We'll take a break. Yes. Yes, Arunachal.
Item 10.
Mr. Das. Yeah.
I'm sorry. Milord. Look, this writ appeal has been filed facing a situation wherein the Honorable Single Judge refused to pass an interim order and in a writ petition filed before the Itanagar bench. And we approached this Honorable Court, and this Honorable Court was pleased to pass a stay order directing stay of the transfer of the appellant, Milord. But the appellant was transferred from Longding to Itanagar in violation of their own circular issued by the Personnel Department of the Government of Arunachal Pradesh. Circular says you should not transfer persons in the last year of his retirement. At present, the applicant has only 4 months of service left, Milord. He is retiring in June, Milord. So, just in the last year, in 10th month, he was transferred. Challenging that, initially we approached the learned single judge. Learned single judge, Milord, refused to pass an interim order and directed the respondents that you consider the representation. They rejected it. Then again, the petitioner appellant approached the learned single judge, second round of writ petition. There, the learned single judge Miller took a view, although not in record, because in earlier, since interim order was not granted, so obviously the second round of litigation, the honorable single judge will not be able to pass any order. So notice was issued. That writ petition is pending in the Itanagar bench. And in the interim, Miller, the appellant has approached this honorable court by filing the instant writ appeal, wherein there is a stay order, Miller. As of now, the situation is I have got 4 months service left. I am retiring in June 26/6/2024. So there is 2 options available, Milord. Either to send the matter to continue the interim order and send the matter to the learned single judge to be heard in fresh there on marriage, or Milord, Lordship can take up the entire thing and dispose of it, Milord. So these 2 options are available, Milord. I'll just take your Lordships to the facts, Milord. The appellant was initially appointed on 11/4/1988. The appellant, he was initially appointed on 11/4/1988. Thereafter, he was promoted on 11/6/2001 as assistant engineer and 9/9/2020 promoted as executive engineer.
Give us the dates.
Yes, my lord. 11/4/1988, he was initially appointed as junior engineer.
Hmm.
11/6/2001 promoted as assistant engineer.
Hmm.
9/9/2020 promoted as executive engineer. And his date of retirement is 26/6/2024. He was transferred by an order dated 6/10/2021 from to as executive engineer, Longding Division, Longding. 6/10/2021. This was the order by which he was brought to Longding Division. Thereafter, page 37 is the order by which he was sought to be transferred.
Page
37, my lord. May I read, my lord? It is dated 19/24 July 2023. In the interest of public service, the government of Arunachal Pradesh is pleased to order the transfer and posting of the following executive engineers under Arunachal Pradesh Public Works Department in the places shown against each with immediate effect. My lord, serial number 2 is the appellant. Longding Division to CEHW Zone Office against Sri so and so. CEHW Zone is at Itanagar, my lord. And in my place, Hage Tejang, he was brought from CEHW Zone to Longding Division. Now, against this, my lord, I submitted a representation, page 38. Praying for cancellation of the transfer order. Two counts. I have 10 months to retire, and I was about to complete my tenure in the earlier place of at Longding, my lord. Because tenure was 2 years. Before tenure, we should not transfer. Then your lordship will kindly come to the circular of the issued by the Department of Personnel, Government of Arunachal Pradesh at page 42. We are, first of all, lordship will kindly come to serial number 1B. All postings including, lordship's document, all postings including those in the secretariat in the office of the heads of department and in the district should be normally for a period of 3 years for the sake of continuity. Then my lord will come to serial number D. This is the important provision, my lord. Officers are not to be transferred 1 year before retirement, as it may affect preparation of their pension papers, etc. That the officers should not be transferred 1 year before retirement, and it may affect their pension. This is the view of the personnel department. That's why this circular is issued. However, generally officers posted in the field stroke works division should be posted out to office headquarters 1 year before retirement. So it says whatever you do 1 year before retirement. When a person is about to retire in 1 year, don't disturb him because it can cause hamper in preparation of his pension paper. Now, serial number F, your lordship will also read because it will come into effect now. Any officer against which there are serious complaints should be proceeded against departmentally, since transfers shifts the evil from one area to another, thereby affecting the interest of the people to whose area he is transferred. So it says that if some misconduct is alleged against a person, or if an officer is my lord, not up to the mark of your expectation, don't transfer him to another place. Proceed him against him departmentally, because you should not transfer an evil from one post to another, one place to another place, my lord. If he is guilty or if you find misconduct, draw up a proceeding against him. Now, the next provision, these are, my lord, the periods are shown when the transfer are to be issued, my lord, page 43, 3A. The transfer and posting orders shall be issued by April, that is immediately after the financial year ends, so that the implementation of plan schemes and budget expenditure are not affected by such orders. The officers so posted, transferred, shall take charge of their respective place of posting by May end, that is before the onset of the monsoon and after school examination of their children. Now, this circular was completely violated by the respondents while issuing the transfer order. Then your lordship will kindly come. He approached the Honorable Single Judge first, that page 46. And relevant portion, your lordship will find page 48. This was the first writ petition filed before the Itanagar bench, my lord. The middle paragraph. Under the circumstances, I am of the considered view that no interference is called for the impugned transfer and posting order dated so and so, issued by the Principal Secretary PWD, Government of Arunachal Pradesh, vide memo dated so and so, even though the petitioner may be retiring from his service in about a year's time. Last paragraph, in that view of the matter, Principal Secretary PWD, Government of Arunachal Pradesh, the respondent shall consider the representation submitted by the petitioner on 26/7/23 on its own merit and pass an appropriate order within a period of 1 week from the date of receipt of the certified copy of the order. So there was no interim order pass and direction was issued to consider representation. Thereafter, page 50 is the communication by which the certified copy of the order was furnished to the Principal Secretary PWD, and they passed this order at page 56. This is impugned order.
This is impugned order.
Yes, my lord. Whereas, para 2, my lord. Whereas by order dated so and so, Sri so and so was transferred out in the interest of public service. 3. Whereas I have perused and examined thoroughly the representation submitted by EEPWD Longding Division, his health issues and his treatment will not be affected as there are better medical facilities in the state capital. Number 1. Similarly, as far as his preparation and submission of pension papers are concerned, the DAP and Director of Accounts and Treasuries is also in state capital, hence it will help him. They say, even if less than 1 year is left, since we are transferring you to Itanagar and the office is situated there, so it will not trouble you. But the personnel department circular that I referred, my lord, it very specifically says that whatever you want to do it 1 year before retirement. If you want to transfer a person out, do it 1 year before retirement. If you want to transfer a person from a field division to headquarters, do it 1 year before retirement.
The transfer order is not under challenge.
It's under challenge, my lord.
So there are 2 impugned orders.
2 impugned orders, my lord. So the Principal Secretary PWD is taking a view over and above the view expressed by the personnel department, my lord. Personnel department, which has the authority to issue circular containing the service condition of the employees of the Government of Arunachal Pradesh, the Principal Secretary PWD is, my lord, going above that decision of the personnel department. Now, there is another matter Similar type, wherein also 6 months was there before retirement, he was transferred. The appellant approves this honorable court. I have this honorable court was pleased to pass an interim order that your lordship will find page 8, page 57, annexure 8. Herein also similar situation, relevant portion your lordship will find page 58. Heard on the prayer of interim relief, the appellant here is presently posted at so and so. He is to retire on 31/12/2023. On the verge of his retirement by the impugn order dated so and so, the appellant has been transferred at DCF in the office of the CCF so and so. Learned counsel for the appellant submits that the transfer of the appellant in the eve of his retirement is absolutely unwarranted and contrary to the guideline. In view of the peculiar facts of the case, we hereby direct that the effect and operation of the impugn transfer order dated so and so, so far as the appellant is concerned, shall remain stayed. Lord, during the operation of the stay order, this person retired and this writ appeal has become infructuous. Then your lordship will kindly come page 60, by which the private respondent he took unilateral charge of the post on 28/7/2023. Then my lord will kindly come to page 61, the order passed in the second writ petition, my lord. Uh, 62 is the relevant portion, my lord, page 62. The petitioner had earlier approached this court by filing WBC so-and-so, and this court declined to interfere with the transfer order. But considering the fact that the petitioner has submitted representation on so-and-so, the court directed consideration and disposal of the same its own merit. The representation was rejected, and therefore the petitioner is again before this court. So-and-so and the senior counsel submits that in issuing the transfer order of the petition, the respondent authorities have flouted the transfer guidelines issued by circular dated 2/6/1998, wherein it has been clearly provided that the officers should not be transferred 1 year before retirement, as it may affect preparation of their pension papers, etc. The learned senior counsel submits that the petitioner is due to retire in the month of June 2024, and therefore transfer order issued to him should be set aside. In view of above, issue notice returnable in 4 weeks, say so and so, so and so. Now, this writ petition is pending before the Honorable Itanagar bench. And against not passing any interim order, we approach this Honorable Court. And this Honorable Court was pleased to pass an order dated (24/8/2023). In the writ appeal, your lordship will find lordship's got me. Yes. Heard so and so, learned counsel representing the appellant also heard so and so. Issue notice heard. Then the appellant who is presently posted at so and so Longding division so and so has been transferred to HW zone office Itanagar, wide ordered at so and so, when he has only 10 months left for his retirement. In view of above, we hereby direct that there shall be stay on the impugn order dated 19/24/7/2023 until further orders. So the impugn transfer order was stayed by this honorable court in the writ appeal. Now, my main contention is that they have violated this clause D of the circular dated 2nd June 1998, which very specifically says officers are not to be transferred 1 year before retirement, as it may affect preparation of their pension papers. That is the first condition. You should not transfer an officer 1 year before retirement. Second, generally officers posted in the field and work division should be posted out to office headquarters 1 year before retirement. So even generally also, if you want to post an officer out of field or work division, that should be done 1 year before retirement. Now the respondents, they have filed their affidavit that your lordship will find. They have come up with a stand that there were serious allegations against me as because I erected some road signs in Longding having the message of God. That is the stand, my lord. If your lordships kindly come to the affidavit filed by the government of Arunachal Pradesh. Page 66 will be the running page.
64.
Starts from 64, my lord. Yes. Relevant paragraph. Yes, it starts from 64 and relevant paragraphs. Page 66, para 4. May I read, my lord? That the deponent begs to state that the appellant is transferred from Longding to Chief Engineer HW Zone Itanagar in the interest of public service and administrative convenience vide order dated so and so. As per Department of Personnel Circular number so and so, serial number 1D, the officer is not to be transferred 1 year before retirement as it may affect preparation of their pension papers, etc. However, generally, officers posted in field work division should be posted out to office headquarters 1 year before retirement. Hence, the appellant was transferred to headquarter office, which is located in the vicinity of the office of the director, audit and pension, where pension matters of retiring servants are dealt. As such, it is reiterated that the appellant's transfer to headquarters would rather facilitate him in preparation and submission of his pension papers for timely release of his pension benefits after his retirement through the headquarter office in Itanagar. Though Itanagar is around 400 kilometers away from Longding, the locations are well connected with highways and the applicant can reach his new place of posting in 7 to 8 hours by road. So in sum and substance, what they say, forget about 1 year. Forget about 1 year, written in the circular. You are taken to headquarters wherein the office of pension is situated. So it will facilitate you. But at the same time, the respondents will not totally overlook the mandate of the circular, wherein the personnel department says that 1 year before retirement, if you transfer a person, that will affect his pension preparation. The lordship is aware.
But there's also another condition.
However,
However,
if you want to do it before you 1 year of retirement. If you want to do it, fine, you should not transfer. But if you want to do it 1 year before retirement. Here, that was also violated. That was also violated. I was short of 1 year. Now, though, I have only 4 months left, my lord. Now it is absolutely impractical to, it will have serious consequences in preparation of pension because all the things will be moved from my papers are, my lord, prepared here in Longding now. So if I have shifted from Longding to Itanagar now, it will have serious consequence. Now the second contention, they have said that regarding misconduct, this transfer, although they have said that it was issued in public interest, from the affidavit of the respondents transpired that it was a punitive transfer. Para 5, page 67. I erected some road signs having the message of God in Longding, 8 road signs, my lord. I'll just read, then I'll explain, my lord. The deponent begs to state that and apprise the Honorable Court that one Vijay Vinayak Joshi, son of late Vijayak Joshi, resident of Tal, Dapoli, Mardi, Anzirle, Ratnagiri, Maharashtra, through Veer Vikrant Singh, Advocate, Deputy Advocate General, State of Maharashtra, Supreme Court served legal notice to the Deputy Commissioner, Longding District, Sri Bani Lego, for erecting road signs across the district with intent to promoting Christian religion and proselytizing the public of Longding by undermining their indigenous faith system with the use of government fund of PWD, which was absolutely false, my lord. I never used. Under the appellant as the incumbent executive engineer. As per legal notice, it is in violation of the constitution and secular laws of the country. In this regard, the Deputy Commissioner, while forwarding the legal notice to the appellant Sri So-and-so, Executive Engineer, PWD Division, Longding, stated that the erection of signboard in the district is the handiwork of him, i.e. the appellant, and directed the appellant to reply to the said legal notice within 3 days. Such act of appellant, Milord, this is important, such act of appellant, being a government servant, could create law and order situation in the district, and could create, Milord, and his continuance in the district may not be appropriate for containing law and order and smooth administration of the district. So there was administrative exigency to transfer him out from the district in the interest of public service and administrative convenience in the district, and to avert further misuse of government fund. Milord, absolutely, Milord, false statement, I would say, because I never use government fund. I submitted reply. I'll take your lordships to that, Milord. Then, if your lordships kindly see, it is further stated that the appellant through his advocate sent reply dated 6/7/2023 against the legal notice dated so-and-so, wherein in paragraph 4, it was admitted by the appellant that the signpost was erected by him on his own expenditure and no government funds were used for the same. The said admission itself goes to show which is unbecoming of a government servant, my lord. They have come up with a conclusion that my conduct was unbecoming of a government servant, so I committed serious misconduct. It is also submitted that during the relevant time in social media, the pictures of the signage erected promoting a religion went viral, and because of it, there was apprehension of breakdown of law and order. Further, it is stated that the disciplinary action against the erring officer, i.e. the appellant for the instant gross misuse of his official position, was not initiated by the government purely on humanitarian ground, since the appellant is on the verge of superannuation, retirement on 30/6/2024. Any departmental action at this stage may cause severe hindrances in clearing his pension papers. Hence, on humanitarian ground, no disciplinary action was taken apart from transferring him out from Longding to PWD zone office Itanagar. It is clarified herein that if any disciplinary action is at all required, shall be initiated in due course of time. So basically they say, first allegation, I use public money in erecting those road signs. Number, I was preaching Christianity in the area by, my lord, incorporating the message of God in those road signs. And by these two acts, my lord, I committed misconduct. Now, I'll take your lordships to the reply given by the petitioner against the legal notice, my lord. That your lordship will find page 85. Because two things I would like to clarify, my lord. It was very categorically stated that no public fund was used in erecting those road signs. Second, those road signs were removed immediately after receiving the complaints from the deputy commissioner. Immediately. And third, there was no law and order situation that occurred in the area. Fourth is that, Milord, there is no question of preaching Christianity because, Milord, the entire population after the 2001 census, Milord, the entire population of Longding belongs to Christian religion, Milord. Only I have, in my reply, Milord, I have stated only 4 households are there who doesn't belong to Christian religion, Milord. But and otherwise, the entire village belongs to Christian religion. So there is no question of my preaching, Milord. I erected.
Come to page 89.
89, Milord. Yes, Milord.
It's shown PWT Longding.
Yes, Milord. Milord, this explanation I have given this explanation, Milord.
What is this?
Actually, Milord, there was no intention on my part to incorporate. Milord, what happened? The painter whom I gave the instruction to prepare, Milord, that explanation I have given in my reply to this, Milord. Whom I gave the work to do, Milord, he, Milord, did not know my name. He knew me as executive engineer PWD Longding, so he incorporated this. Otherwise, there was no use of official fund, Milord, in doing this. And my Lord, these were removed immediately after receiving the complaint from the deputy.
Painter is not the party to the proceeding.
No, that is my explanation, Milord. That is my explanation in the reply. So, no public fund was used, Milord. And from the statement of the respondents in para 5, it can be very well it transpires that they have issued the transfer order taking into account my act as misconduct. If you have done so, then it's a case of punitive transfer, Milord, in my respectful submission, apart from that violation of 1 year, Milord, in the circular. Because in the circular, at para, I'll just take your lordships again, page 42, if your lordships kindly come, para F, it says,
Yes.
para F, it says, Milord, any officer against which there are serious complaints should be proceeded against departmentally, since transfer shifts the evil from one area to another, thereby affecting the interest of the people to whose area he is transferred. So, don't transfer a person 1 year before retirement. However, even if he is in the field unit, don't transfer him. Second, if you are alleging misconduct against a person, proceed departmentally. Don't transfer him. And if your lordships kindly see my reply to the legal notice given, I'll just take your lordships with 2 paragraphs, page 85, that my client is shocked and outraged by the allegations made by your client without proper investigation and proven the matter, as my client has never indulged in any activity as alleged in your notice by your client. Lord, I'm reading page 85, Lordship. That my client has merely erected 8 numbers of signs written as I love Jesus, and it was not a road sign, and to say I love Jesus is not against the principle of law. Neither my client has violated any provisions of law or committed any crime under Indian Code of Law of Land. God is all for all and equal for all. It is enshrined in Constitution under Article 25 of Indian Constitution. Secularism state means equal treatment of all religion by the state, and my client is Christian, and Article 25 of the Indian Constitution allows any individual the freedom of conscience and free profession, practice and propagate his or her religion, and writing in signs as broad as I love you, God is not a crime. The allegations alleged in para 3 in your notice is totally false, and your client has tried to implicate my client in a wrongful manner without any proof, and the allegation alleged as use of government fund to erect the signs across the district is totally baseless and concocted one, as he has erected the said signs by his own expenditure. An allegation as use of government fund by my client to erect the signs for the religious work is a kind of defamation to my client, that my client has never received any notice information in regard to the same issue, or to remove the erected signs directly or indirectly from your client earlier. This is the first notice which my client has received through Deputy Commissioner Longding, and the Deputy Commissioner has directed my client to remove the erected signs installed by my client. Accordingly, my client has removed the said erected signs immediately on 5/7/2023 and deposited at Longding Police Station. So he erected those signs, my lord. Firstly, there is nothing like, my lord, I'll have to preach one religion, because the entire village of the Longding belong to Christian religion, my lord. That I have stated in my affidavit in reply. If your lordships kindly come to page 98. '97, my lord, para 6. Lordship.
Even if it's true, where's the license to write all this thing in the official, I mean, the signage?
In the name of the department.
Yes.
My lord, that was a mistake on that. That is certainly a mistake.
That is an
But if I
Mistake and
Madam,
still,
more for you.
if it's the mistake and still, method and still, you don't have.
So if no, what I'm trying to submit before your lordships is that, my lord, I cannot, my lord, deny the fact that PWD was written in the signage. That I have explained here also, my lord. I never instructed anybody to incorporate the name of Public Works Department there. It was inadvertently done, and I removed, my lord.
Signage by the department only.
No. It was done by the appellant on his own expenditure. My lord, what happened?
Okay, wrong signage.
My lord, the school children go to the school. Only that some message of God will be there when the school children. My lord, I don't know. I cannot.
Are you an officer or a social worker?
My lord, no. My lord, some people, my lord, it happens that even if he's an officer, he remains more religious, my lord. So I have asked him, my lord, why you did so. He's very honestly, he said, my lord, I never wanted the name of PWD there, my lord, but I did it because through that road, school children go to school. So they'll see some message of God while going to school. So that's why I incorporated those signs. And when the complaint came, I immediately removed. And one thing I'd like to submit before your lordship is that there was no law and order situation happen. Had there been any occasion, one instance, that any other person except this person from Bombay, any other person has raised any allegation against me, I would have understood. The projection made by the state that there will be communal violation. Look, there was no other community in the entire Longding village, my lord. 99% people belong to Christian religion. That I have stated para 6, my lord. down below, my lord. Yes. Then in the next page, my lord, page 98. Accordingly, he put the office address that the painter in the appellant did the road sign. There was no intention of the appellant to use either his official position or official address in the road sign. Further, the contention of the respondent number 1 and 2 that putting road sign incorporating message of God would create law and order situation in the district is not only unfortunate but also unbelievable. It is stated that as per the 2001 census, the population of London is 51,000, and out of the above population, only 4 households are not non-Christian, which include 1 retired additional deputy commissioner, 1 teacher, and 2 other households. The entire population of Longding adopted Christianity. Therefore, the deponent is absolutely not required to promote Christianity because the entire population of Longding belong to that community. Now, the question is as to whether the respondents have had any record of law and order situation in the district since August 2023. If answer is no, then the reason for which the appellant was transferred was arbitrary and unreasonable. So in my humble submission, my lord, not only they have violated that 1 year clause, and page 99, my lord, I have stated that this transfer is in lieu of punishment and that is punitive in nature, my lord. You cannot pass transfer order in lieu of punishment. Your own circular says. Your own circular says that if you find any misconduct against a person, proceed against him. Even if I am on the verge of retirement, if the allegations are so serious, if there is any communal violence, they know it, my lord. There is no communal thing. Only that letter came from Mumbai, given to me. I wrote my reply and immediately removed the signs and gave it to the police station. After this, nothing happened. Only I don't know what is the background, but in the transfer order, my lord, they say in the interest of public service. And at the same time, they violated both the conditions of their own circular. 1 year and, my lord, conduct. If you find misconduct or infirmity in conduct of the person concerned, you should not transfer him out. And I am, my lord, having only 4 months of service left, my lord. And the private respondent, he is the youngest executive engineer of the department. Recently, he got promoted. He has got long career to go. At least at this fag end of service career, 4 months, Lordship will kindly, if even assuming, my lord, some mistake was done by him, my lord, he has sought apology and he has immediately removed those signage, my lord. There was no intention on his part to incorporate the name of the department. One judgment I am relying, your lordships, just only have a look, my lord. Lordship is aware of this judgment. I am just reiterating it, my lord. Para 4, 5, 6 are the facts and ratio is at page para 16. Inter alia on the premise that the employees posted at Bhopal office of the respondents apprehending discipline. Lordship got, my lord. para 4. The facts of that case. Here some complaints were made. The respondents apprehending disciplinary as also criminal proceeding at the hand of appellant on the basis of reassessment of the files undertaken by him, an anonymous complaint was made alleging caste bias on his part, pursuant whereto an order of transfer was passed against him on or about 28 to 2005. So some allegations were there, then transfer order was issued. Prior thereto, he filed a representation stating that he had been undergoing some treatment and he should be retained at so-and-so. The appellant, however, contended that in view of the fact that he had taken action against some erring officer, they were instrumental in sending those complaints on the basis of whereof no action should have been taken in the light of so-and-so. Now, if your lordships kindly come to para 16, what the ratio has been laid down by the Honorable Apex Court. Indisputably, an order of transfer is an administrative order. There cannot be any doubt whatsoever that transfer, which is ordinarily an incidence of service, should not be interfered with. Same in cases where inter alia mala fide on the part of the authority is proved. Mala fide is of two kinds: one, malice in fact, and second, malice in law. The order in question would attract the principles of malice in law, as it was not based on any factor germane for passing an order of transfer and based on irrelevant ground, that is, the allegations made against the appellant in anonymous complaint. It is one thing to say that the employer is entitled to pass an order of transfer in administrative exigency, but it is another thing to say that the order of transfer is passed by way or in lieu of punishment. When an order is transferred is passed in lieu of punishment, same is liable to be set aside, being wholly illegal. So this is my second ground, my lord. First ground is there. Second ground is that if you are alleging misconduct against me, you are to proceed against me. The department tried to show some benevolence by saying in their affidavit that since I was on the verge of retirement, so no DP was initiated. But rule requires, your own circular requires that if any misconduct is found against me, you are to proceed departmentally. Don't transfer on the ground of misconduct. And the Honorable Apex Court also very clearly says that when an order of transfer is issued in lieu of punishment, same is required to be set aside. And there are enough material in the affidavit of the government that it was issued in lieu of punishment, Milo. Instead of initiating proceeding, giving punishment, he was transferred, Milo. There was no public interest involved, Milo. So that is my humble submission, Milo. He has got only 4 months left. Even assuming not admitting, Milord, some mistake has been done by him, Milord. Lordship will kindly condone that thing and taking into consideration that he has only 4 months left in service on the verge of retirement. At this stage, if he is sent from Longding, Milord, there will be serious problem in his release of pensionary benefit. So Lordship will also consider sympathetically and allow him to spend his remaining 4 months life, service life at Longding. Because in his entire service career, Milord, not a single complaint he had faced. This is the only first complaint he has faced in his entire service career since 1988. So in my humble submission, Milord, this writ appeal deserves to be allowed by interfering with the impugned orders and allowing the petitioner to continue at Longding till his retirement, Milord. That is of 26/6/2024. We are in March, my lord. Sorry, my lord. We are in February, my lord. 2nd of February. February, March, April, May. 5 months. So that is my humble submission, my lord. Deeply obliged for the patient hearing.
The facts have already been gone through, my lord.
Goswami,
I don't think we have time. This court is sitting only up to 1 o'clock.
Right.
At 2, there's a different division bench.
Right.
So we'll keep it parted and take up the next.
Monday, madam.
Monday we can take.
Monday, short, I will short.
Monday.
Monday difficulty is there.
HK Das, then I concept. Also, hard is over. Additional application.
मारिए दियो
For the
गुजा मारे दियो
and Mr. R. Fisherman. What is party? What is for the, you know, fifth.
Well, there is an interim order passed, my lord, earlier. That may
To continue till the next.
Monday.
Highly of this.
I'm mentioning in item 24, 22, 20, Lordship. Item 20, where a similar interim order was passed by your Lordship. Well, this is the order. Our urgency is that the post will be filled up and your Lordship is not sitting at the second half. So in terms of this order, your Lordship may admit it's a similar case. Well, the issue is that through a summary procedure, we were appointed in substantive vacancies, we were removed. The procedural guidelines under 311 was not compliant. The learned single.
Take it up on Monday then.
Well, not only that, in the meantime, they might go ahead and fill up the post.
Tomorrow is Saturday.
Yes. And their Lordship will fix it on Monday.
Item 20.
20.
Item number 11.
Obliged.
Medical admission.
Monday.
Item number 11. Can it be taken some other time unless Lordship will fix the matter?
May be taken up on Monday, my lord.
Not Monday, but Monday I will not be here. Probably. On Wednesday, Lord.
Has it not been in process? Become in process?
No, my lord, since I will continue for that time.
9th.
My lord, regarding item number 14, my lord, the date may be fixed, my lord. I have mentioned this matter, but
When do you want?
my lord, this, my lord, this next week, my lord, any date.
Let it come up the week after that. 21st.
21st, my lord. My lord, can it be little earlier, my lord? February
19th. Item 14, 19.
In respect of item number 18, I have other matters before your lordship on 8th. Can it be fixed on 8th?
Item
18, 1-8. I am there, of course.
8.
8.
Lordship, item 21, Lordship it may come up next week, Lord. 21.
Next week is quite full.
Lordship is a new matter, Lordship. Today it has been listed.
Okay. 7th.
Much obliged.
relates to a departmental proceeding, this matter, Lordship. My
Hmm?
senior had argued it earlier, Lordship.
Hmm.
And
This is the written argument.
yes, Lordship. That is the argument. The basic thing here in Lordship, there are two limbs of argument, Lordship, in this. Lordship, the first one is that they have alleged, Lordship, that uh, I was working as a Lordship administrative officer, Lordship, and during that point of time, as per instructions of the branch manager, Lordship, and policy was issued, and Lordship, the vehicle that was insured was Lordship met an accident the next day.
Who's on the other side?
Mr. S. Dutta, Lordship. Senior advocate, Mr. S. Dutta.
Where is he?
He was here, Lordship, but now I don't see him, Lordship.
Wait for some time.
Lordship.
You just return it back. You just keep it with you. If he's not here, we'll fix a date.
Lordship.
Item 2. Item 2.
Will require some more time, Lordship, to file a return. Would it be Lordship in the last week of February or what?
You want it extended so long?
Lordship.
Why?
There's some unable to do so, Lordship. There's some inconvenience on our part.
Okay, on request made by Mr.
Can go to
N. Gautam, then a counsel for the petition. When do you want?
on 27, 28th February. Lord.
We'll have it on 29th.
When Lordship.
29th.
Item 3.
Also, it's been prepared, ready to file.
Yeah, for the petitioner?
Yes.
For respondent number 4, 5, and 6, Your Lordship, the quality authority.
Hmm.
My senior friend here is for the private respondent.
And how about the higher education? No, you have to supply it today. You're not ready. Then you give it back. We'll fix it some other day. On request made by Mr. K. Gogol and Standing Council Higher Education. We'll have it on the same day, 29th of February. 29th of February. Okay. Just keep it on 29th,
Yes,
you
sir.
bring it. Otherwise, again, there may be
Yes,
some
yes.
dislocation.
Item 4.
I'm submitting written argument on behalf of DVAS.
On behalf of respondent 9, Lordship. Written argument.
We need some more time. We'll file next.
What?
We'll file the written argument next time. Next.
No, keep it with you. She wants some more time. Okay. You're for the department.
Yep, madam.
On request made by MS.
Okay, that's.
K. Das, Learner Standing Council, Secretary Education. We'll have it on 29th this also. 29th. We'll have it on the same day, that's better.
Item 5.
Your Lordship, as per your Lordship's direction, we have prepared the written argument.
Higher education.
So Lordship, on 7, Lordship. On 7.
You want it on 7?
On 7, Lordship.
You bring it on
7.
On request made by K. Gogol and Standing
On 7.
Higher Education. Instead of 7, why not we have a uniform date?
Lordship?
We can have a uniform date.
Lordship, on 7, Lordship. Some urgency is there, Lordship. On 7, Lordship.
Just 7.
7, Lordship.
Yes, some urgency is there.
Lordship.
Can you do it by 7?
Lordship, I can, even Lordship by Monday also we can. But if Lordship allow on Monday, then Lordship.
We'll have it on 7th. You
Seven.
bring it on
7.
Yes.
Okay.
Item 6, 7, and 8.
Your Lordship, in item number 7, I filed my written argument, Lordship.
How about 6 and 8? Buyan? How about the
Same time, same.
okay? Request made by MS.
Kedar.
Kedas, Understanding Council, School Education Department. When do you want? Can you do it by 7th?
No, my lord, 20.
29th.
9 and 10.
Same order.
My lord, this is a matter of return 1, my lord.
Yes.
Cannot be on 7th, my lord.
She wants it on 29th. Let's see.
Most of they are on the verge of retirement. That is why, my lord.
Okay. Make sure you finish it on 20. Yeah.
11.
May pay your lordship.
I am the writ petitioner, my lord.
May pay your lordship. I am appearing for the college authority, response number 3, 4, and 5. The principal, vice principal, and governing body. My lord, I am submitting my written submissions today, my lord.
How about the other higher education? Go.
File, my lord. 29.
Lordship.
Time for the respondent number
1 minute. How about a little early? When?
Around 15, 16.
21st?
Yes.
On request made by Mr.
Yes, sir.
Yes, does the Understanding Council, Secondary Education Department, Higher Education Department.
And for the respondent number 7, lordship, I prepared.
No, keep it.
Yes.
List on 21st. I said 21st. No? Yeah.
15. Item 15.
No, item 12 and 13.
Item 15 is tagged with 16, 17, and 18, your lordship.
No. 12, 13, and 14.
Item 12, 13, and 14.
Item 12, 13, and 14, my lords. We pray for 1 week's time.
Okay, on request made by Mr.
By 7th, we will file the
By Mr.
MH Rajbor.
MH Rajbor, Leonard Counsel for the petitioner. List on 21 will fix it. 21st.
21st.
Yes. Make sure you get.
Yes, ma'am.
15. 16 and 17.
Yes. Your lordship, I appear for the college. We have been recently engaged, your lordship. In fact, after the matter has been substantially heard, we'll be filing a written argument as well as a short affidavit to bring on record a subsequent event, your lordship. We'll be covering the entire aspect of the matter by way of the written argument. We also seek some time to file, so your lordship is pleased to fix the last date that your lordship fixed, February 29th. It will be
Okay, on request made by Mr.
M. Sharma, your lordship.
M. Sharma, Leonard Counsel for respondents.
For college authority, your lordship.
For the college authorities. List on 29th.
29th, your lordship. We're grateful for that. I'm grateful.
Item 19.
In advertent, no, lordship, we have brought it to the lordship. We have left it in the old building, lordship. We'll bring it and submit it to the court master. We have brought it back.
You have
Yes, we are ready. We are submitting the written lordship.
Submit the court martial. Today itself. Today itself. Heard, Mr. Mr. R. Moyo. Okay. You are appearing for the petitioner? Then a counsel for the petitioner. Also heard, Mr.
S. Sutadhar.
S.
Sutadhar.
Sudhadhar for the respondents 2 to 7.
2 to 7.
Okay. Written arguments have been submitted. Hearing concluded. Judgment reserved.
20.
Appear for the private respondent. Not the same day 29 to February.
Okay, on request made by Mr.
And Gautam.
N. Gautam, then the counsel for respond number 12. List on 29 you want?
29.
29.
21.
Also, during the course of the day, we'll be filing it. Just getting it ready.
About the other side? Higher education?
Date may be fixed, 29, 21 or 20.
21 will fix it then.
Then together
On request made by Mr. S. Das, then the
29, 20.
Standing Council Higher Education, list on when?
29, my lord.
29th.
Very good. Like
22, 23, and 24.
I'm ready with the written argument.
Yes.
I'm appealing for respond number 5.
You are ready?
Ready, Lord.
Where's Barbujari? Respondent number 5.
Right, Lord.
Oh, you're appearing on behalf of Mr. Barbujari.
Lord.
And how about the other 6, 7?
7. Respondent number 7.
You ready?
Standing council health is also ready.
How about the health department?
Lordship, I am appearing on behalf of Mr. D.P. Bora, Standing Council of Health Department.
You ready?
Yes.
Written argument?
You ready with your written argument?
Lordship, I have to take.
Okay, we'll list it on 21st. Get it ready. On request made on behalf of Mr. B.B. Bora, then the Standing Council Health Department, list on 21st.
Item 25.
May I please your lordships? Last talkers of your lordship directed my learned friend to file additional affidavit. They are disputing the petition number 1, 2, 3 are not appointed compassion appointment. Can they file the additional affidavit? If fresh hearing required, may I proceed, lordships?
Yeah. Where's the file?
One petition there.
Are you filing a reply? No.
No, they are documentary, lordship.
One minute. 1 minute. I have a review part third matter.
Lordship.
We'll have this on Monday.
Monday.
Yeah.
Lordship.
Monday or Tuesday.
Monday, ठीक है sir. Data more Monday.
Third FI by Royal and I counsel for the petition as well as MS R. David and the CGC for the respondents. Stop. List the matter again on 5th.
Obliged, lordship.
Item 26.
That is a review application, lordship, regarding that is.
My senior DK Rajesh come from the old building.
I am just supposed to produce that PF statement and the original declaration.
Did you get any of the PF statements?
Yes, lordship. The PF statements are yearly statements. The timeline is indicated at the top hand portion.
1 minute. Timeline.
I'm just producing, lordship. This 5 years I'm producing. Lordship will see, I have just highlighted by a circle. The 5 years I have indicated. Now the date that is below, that particular date is the date when the printout is taken out from the software. That is why this date will be today's date. But this is not relevant. What is relevant is the PF statement for the timeline is there, the right hand side, top corner.
Okay.
So this will be always the date when the system has been logged into and the printout is taken from the system. Because everything is now paperless now. And this has been signed and sealed. These are the genuine documents for last 5 years. Everywhere Lordship will see it is 63.
So this you have printed out from the
System. It's called SAP, SAP. It's a computer system because it
from
is
the
paper.
portal.
From the portal, yes.
So when he has his printout also, he should have the signature, isn't it?
Definitely. Printout is taken and then signature has to be there.
My lord, everything is crystal clear. Some question maybe arises, and my senior is came from the old building.
And the declaration.
Within 2 minutes, he is come.
The declaration original. This is the entire bunch of papers. The last page will indicate that
last page.
The last page. Lordship will see the age 63. And this was entered at the time when he had joined his service. This is the original papers. Signed by him.
I may be allowed
Today
to
it
call
is
him.
too late in the day to now file in a review application and say that it has to be 69. There are Supreme Court judgment also which says, otherwise also at the fag end, the person cannot come for change of his retirement age. I can produce a judgment also.
Where is that PF statement that he was relying upon?
Page 58. 28 Lordship.
Coming.
And against this, at page 49 of our affidavit, we have issued a so cause saying that this is a manipulated document. And how did you get hold of this document? And therefore, he was so cause. Page 49 of our affidavit. This is the position.
Statement, you can auto submit the lockup in the month of February.
See, Mr. Das, PF statement is generated yearly. Okay. And he has submitted the year-wise PF statement,
5 years.
which is contains the signature and seal. He has also submitted the PF statement for 2022-2023 with the signature and seal. And compared to your Annexure G, which is the same PF statement of 2022 to 23.
Yes, my lord.
Here, the date of birth is 1st March 1963. And yours is 1 March 1969.
Yes.
And without the signature.
Yes, my lord.
Without signature and seal. Have you got a spare copy?
Spare copy of?
This PF statement?
Yes, Lordship, yes.
Just hand it over to you.
How can do?
The last page. Last page.
Last page. এটি তো তাহলে রিপ্লাই তো নাই সাইন করেছে একজন about the signature of this document, my lord, I cannot say, but the affidavit which they have filed and annexed a document, a PF statement, in that PF statement was also bear no signature, my lord. They have filed. They have filed, my lord.
Which affidavit?
In their affidavit in my lord review petition.
Execution to
Page 50. So what happens is when the printout is taken, sometimes there may be a lacuna, there may be some shortcoming. The signature may not be there. We have just annexed the document. Page 50. But this will not take away the fact that otherwise also 63 is what is figuring in all the papers. Apart from that, only paper at page 28.
And what is this?
This is the original declaration submitted by the petitioner at the time of his employment in 1992, wherein he has signature and says 1963.
But in his document, yesterday, I submit before Lordship that the date was erased, not date was not erased, the eraser was the name of the village. So, I withdraw my that submission. I have gone through it, the date of birth which was written, that was right, So, for the name of the village is concerned, that was Whitener.
Yes.
Used of Whitener.
There is
So,
no interpolation in so far the date is concerned.
No.
There's no interpolation.
Yes.
Why
I am
will
not on that.
PSU
I am not
enter
on that.
into all this?
The statement declaring the family, you cannot hold the date of birth of a person. We have annexed the school certificate which was issued by the headmaster.
These were already re-agitated. They cannot re-agitate in a appeal. I am just producing a judgment. In a review, these issues which were already in the petition and were decided upon cannot now be re-agitated. I'm just producing a.
What is this called?
This is the PF admission declaration. In fact, in a lawsuit judgment, lawsuit has indicated about that. May I just produce one judgment regarding the scope of a review application. Lordship knows that, but just for persuasive. Paragraph 15, 16, and 17. 17 is very categorical. Already available. I don't know. Specific paragraph, yeah. Narrative.
Okay.
You're looking.
You can take this back.
Yes, ma'am.
Dismissed. Out of
Obliged,
your.
ma'am.
Into my chamber.
One observation maybe given, my PF retired benefit that should be disbursed immediately.
That will be a subject of a different cause of action, the different petition, probably, if it is not paid. How can it be brought in a review application pertaining to a case regarding retirement age?
I may be permitted to file written argument in another item 21.
It speaks on 29th.
Well, I'll ready it, if you're lucky permit.
No, keep it, bring it on 29th.
29, I may not be available.
You can give it to.
Obliged.
One more matter.
Item 1.
Lord, I'm extremely sorry. I could not be there when it's.
No. That's fine.
Lord, can your lordship provide 2 weeks?
On request made by Datta and a senior counsel for the respondents.
Right.
List on 29th.
Right.
I'm listing the orders on 29th. Lordship.